So where is everybody? Midterm's over? You're gonna miss all the fun. Well, you probably got the memo that I posted your paper assignment for the paper due next month, and it's a little odd, but let me try to explain it. There's this case, Minority Television Project versus the FCC, that has been decided by a panel, three-judge panel, in the ordinary course of business of the Ninth Circuit Court of Appeals. And the court, the three-judge court, by 2-to-1 majority, decided that two provisions of a federal statute are unconstitutional. Those are provisions that prohibit a public television station from airing political commercials and public issue commercials. The panel upheld a third provision of the law, one that prohibits public television stations from airing garden variety commercial type commercials for products and services. And that decision is, we are going to pretend for the purposes of this paper, that decision was the final decision of the Ninth Circuit Court of Appeals, and the government, having lost on 2 out of the 3 provisions, will take, we pretend, probably will take the case to the United States Supreme Court. And your assignment in the paper is to predict, essentially, what the Supreme Court will decide in that case. The format for the paper is not an academic essay. It's a news story reporting that yesterday the United States Supreme Court decided blah, blah, blah. What's throws things off a little bit is that the Ninth Circuit has agreed to rehear the panel decision en banc, that is, by a full court of 11 judges, and to reconsider whether that decision, the 2-to-1 decision, stands. They're doing that next Tuesday in San Francisco, and a separate announcement says you can go if you wish. It would be a good educational experience, and I think it would help you understand the issues at stake in the case. But for the purpose of the paper, we're assuming that there's no en banc hearing at all, and that the case goes directly to the Supreme Court from the panel decision. So if you want to go to the argument next Tuesday, I think that would be great. It's in San Francisco in the beautiful old Ninth Circuit Court of Appeals courthouse at the corner of 7th and Mission, pretty close to the Civic Center BART stop. And it's at 10 o'clock, so it conflicts head-on with our class. And it's an important class. It's New York Times versus Sullivan, and I would hate to see you miss it, but I think it might be worth it to go see the Court of Appeals in action. And you can always catch up on the lecture on YouTube or Cal Webcast. So there's that. And if you have any questions about what the paper is supposed to be about, you know where to find me. This time around, you're going to have to plan ahead, because when you turn in your paper, you will have to turn in with it the draft of the paper that you gave to your classmate editor, showing your editor's notes, comments, questions, edits, and so on. And if you sign your name to something that is not true, that is, you certify that this paper is well written with no grammatical errors, and it happens to be terribly written and full of grammatical errors, not just the writer's grade will suffer, but yours will lose a grade point. So you've got to plan ahead for that draft process to take place before the deadline. Okay, I've started grading the midterm and going through a lot of them, but not enough to give you a complete picture. But I thought while it's fresh in your mind, we ought to go over a couple of the things that were most commonly missed on the test. On the short answer question, the one that was most commonly missed is why wasn't the Sedition Act of 1798 an invalid prior restraint? And most of you wrote something about, well, it never got to the Supreme Court. It was never decided by the Supreme Court. The point is more fundamental than that. The Sedition Act was a criminal law that provides for subsequent punishment, that is, punishment after the fact. It was not a prior restraint at all. The fact that a law is terrifying to people, will put you in jail for 20 years if you say that, does not make it a prior restraint. Prior restraints where the government orders the press, usually, someone, not to publish something in advance. After the fact punishment is not a prior restraint. And the other point that was not accurately stated by several of you was about the Citizens United case, and where a lot of you said it allows corporations to donate to political campaigns or to make contributions to political candidates. It did not do that. It did not say that you can make direct contributions to candidates. It's still the law that that's prohibited. What it did do was authorize corporations to make independent expenditures that may support or oppose candidates, spend their own money on their own produced ads that would support or oppose candidates, not to donate directly. Not a huge point, but I wanted to get it cleared up so that you didn't go around telling your parents that over spring break what Citizens United decided. And then the fourth short answer, in what circumstances can the government obtain a court order prohibiting a newspaper from publishing certain information? That's flat out Pentagon Papers. That's the Pentagon Papers case, in the circumstances in which the government can carry the burden of proving grave, immediate, irreparable harm to national security. It's not the clear and present danger test. It's not strict scrutiny with compelling interest and narrow tailoring. It's flat out the Pentagon Papers test. And then the most popular true-false that was missed by virtually everyone, not everyone, but virtually everyone that I've looked at so far, was number 14, and it said, in the American legal system, only the United States Supreme Court is authorized to declare an act of Congress unconstitutional. And most of you, almost all of you, seem to think that was true. Yeah, in the American legal system, only the United States Supreme Court is authorized to declare an act of Congress unconstitutional. What's the problem with that? Any court can. Any court. One wise student a few years ago pointed out something that should be obvious, but it wasn't to me. I've taken a lot of tests in my day, and true-false tests, and I never realized that. He said, in order for a statement on a true-false test to be true, every word in it must be true. And this one, the key word here is not declare or Congress or unconstitutional. The key word is only. Only the Supreme Court can declare an act of Congress unconstitutional. Well, that's not right because, as you point out, every court can. State courts, lower state courts, federal courts of all kinds. And we've seen examples of the cigarette case that we looked at last week, where the Court of Appeals struck down the federal law requiring those ugly images on cigarette packs. And the other next most popular myth, true-false, was number 23. A statute that makes it a crime to picket military funerals is not a prior restraint. Is it a prior restraint? No, it's a criminal law. It's the same point as the Sedition Act thing. The fact that a law makes something a crime ought to say, have you say, that can't be a prior restraint because it's after the fact punishment. The only thing that happens to you if you publish is you get criminally prosecuted. You don't get enjoined ahead of time and told you can't publish that. Anyway, looking pretty good so far, but we'll see. I mean, those are just, minor points. Today's San Francisco Chronicle, I'm certain that none of you have looked at it, read it, and so on, has a nice bridge between what we have been talking about and where we're going starting today. It's about, the headline is Free Speech Protects Offensive Ads on Muni. And you may have heard about this because we talked about it earlier with those bus signs in New York that were anti-Islam, paid for ads, but run on public buses in New York, paid for by a right-wing Jewish organization, and they're anti-Muslim, anti-Arab type ads. Well, they've got them in San Francisco now. I'm not sure on the buses today, but they're starting right away. One of them, for example, has a supposed quote from Hamas MTV that says, "Killing Jews is worship that brings us closer to Allah." These are offensive, ugly, hateful ads. And the question is, does Muni have to run them and display that to all of us in the Bay Area who get anywhere near a Muni bus or street corner? And the consensus seemed to be yes. The article quotes UC Hastings law professor Evan Lee as saying it's a pretty clear-cut case of prior restraint doctrine. While it's difficult to stop an offensive claim, the recourse is legal action after the fact. Well, how is this a prior restraint? Elia? Right. You figure it out? Good. No, it's right. The Muni has got to decide what it's going to allow to be displayed on the buses. And it picks and chooses. And if it allows political type ads at all, I suppose it could say, we're not going to display any political ads, only products and services and so on. But apparently allows political ads. So if it does, it can't pick and choose among the messages that it finds hateful, distasteful, what have you. And they are deciding that in advance of the publication on the buses. So it would be a prior restraint. And then Professor Lee goes on and says, so if you take out an ad calling me a child molester and I bring a libel suit, then I have a case. But you can't have Muni deciding in advance, you can't put that up. So the writer, who's a good writer, Chuck Nevius, then goes into his opinion thing, and he says, okay, let's have Muni bring a libel suit against the group that took out the ads, claiming that they defamed the reputation of Arabs and Muslims. Not likely, Professor Lee says. The only way it would work is if the ads were so incendiary that they were going to incite riots, that people are going to die. Incitement, not being protected speech. And, as we'll see in a few minutes, it's preposterous to say that Muni could bring a libel suit against the people whose ad it is carrying. And it would not be possible for Muslims, Arabs, any one of a large population, to bring a libel suit. That wouldn't be permitted. And then there's an example of why this sort of offensive speech is protected by the First Amendment. Another person's quoted as saying that by an 8-to-1 vote, the Westboro Baptist Church would pick its funerals and so on. Who was the one in the 8? Right. It was a pretty clear indication that offensive speech is not prohibited. So let's find out about libel. Libel has been with us virtually since the beginning of the common law, back in the mists of history. If you think of the whole universe of law, there's all kinds of law. There's constitutional laws we've talked about. There's administrative law. There's contract law. There's tort law. Torts are civil wrongs. Theories that people who are injured by somebody else to sue them for damages. So there's torts, and there's all kinds of torts. There's fraud, where you cheat somebody, and they're out of pocket a bunch of money, so they sue you for damages for the tort of fraud. Or assault. Assault can be both a crime, where you hit somebody, it can be a crime. It can also be a tort. That is, you can be sued civilly for assaulting someone. The tort of negligence is probably the most popular tort in America, in that it's used in practically every automobile accident case. You rear-end somebody going 50 miles an hour down Hearst, you are negligent, and you're sued for negligence, have to pay damages and so on. Well, another tort, long recognized by the common law, is defamation, which comes in two varieties, libel and slander. Libel being basically written, or in some fixed medium of communication, and slander being basically oral. In California, for whatever reason, defamation on radio or television is considered slander rather than libel, even though it can be on tape and can exist forever. Well, we consider libel in this course because the law of libel is a great inhibitor of what news is covered and how it's covered and what people can say about people in the public eye. And the law of libel, I use libel sloppily to mean defamation. I include slander when I'm talking about libel. Forgive me. If I were being technically accurate, I'd say defamation. Libel's easier to say. The interest protected by defamation, by the law of defamation, by the ability to sue for defamation, is the interest in an individual's reputation. And I forget whether we have an English major among us, at least not today. Maybe some of you can correct my Shakespeare, but in Othello, Othello says something like, "Who steals my purse steals trash, but whoever takes my good name makes me very poor indeed." The interest in protecting our good name, our reputation, is one that we all care about, and that the state provides protection for. The state, through the evolution of the common law, protects all of us against tarnishing, trashing our reputation by means of giving us a lawful, peaceful way of repairing it by suing somebody, rather than taking a sledgehammer to their car or to their head. That kind of self-help, we provide a legal means of redressing the damage caused by somebody trashing your name. So to get into, and I have to say that the tort of defamation was purely a creation of the common law, going way back in England, and was recognized by the colonies and was recognized by every state, but it's purely a question of state law. Common law, state law, not federal law. What are the requirements to prove a case for libel? Well, that depends on what state you're in, but there are some core elements of the tort of defamation that are common to all of the states. So to get into what libel is about and what has to be proved, let's consider let me find this first, the case in the Reader about Arnold Dorsey. We got Arnold Dorsey, whose stage name is Engelbert Humperdinck. Have you ever heard of him? No? I'm not surprised. John, you have to be of a certain age, I think, too. Yeah, tell me who he is.
I think I already know. He was the singer, kind of.
Yeah, he's a Las Vegas guy, and I think sort of a lounge singer, a lounge singer kind of guy, the kind of guy that the grown women throw their underpants at him on the stage. Apparently very popular in Las Vegas and an important guy, well-known figure in Las Vegas. But his real name is Arnold Dorsey. I'll call him Dorsey rather than Engelbert Humperdinck. But Dorsey apparently fathered a child out of wedlock, as we used to say, with a woman named Kathy Jeter in New York. And he agreed that he was the father. He didn't contest paternity and agreed to make child support payments. And after a few years went by, Kathy Jeter, the mother, took Dorsey back to family court in New York and sought an order increasing the child support payments and requiring Dorsey to get life insurance, naming the child, as the beneficiary. And the reason that she sought this relief from the court was because her filing in court alleged that Dorsey had AIDS. It's HIV positive. Had AIDS and had been treated at the hospital in New York. And the National Enquirer, that beacon of American journalism, yes?
I'm just wondering, why is that a reason for her to insist that he is like...
Because he may die very, very soon and won't be able to make the child support payments. So he should get insurance to make sure that the child is not left penniless. The National Enquirer runs a front page story with a picture of Dorsey next to the headline, "Mother of his child claims in court Engelbert has AIDS virus." And the article in the interior of the newspaper says, "Mom of superstar singer's love child claims in court Engelbert has AIDS virus." And there you see, he's got his shirt open. I'd throw my underpants too. I don't have the, I couldn't find the actual Enquirer cover, but you know the nature of the National Enquirer, purely a gossip magazine, and they specialize in love child, apparently. They not only said that Engelbert has the AIDS virus, but the article quotes Kathy Jetter's affidavit filed in court twice, and quotes her, goes beyond the affidavit, and quotes her as saying, "I never would have filed the court papers if I wasn't 100% convinced he has the AIDS virus." And the article also quotes a private investigator for her, saying that our allegation here is based on an intensive investigation of the singer. During the past 5 years, he was tested positive for the AIDS virus and treatment at Sloan Kettering Hospital. The third paragraph of the article contains Dorsey's denial. Doesn't have AIDS, and includes a picture of him with the caption, "Engelbert denies